What is the process to patent an invention? This is the most frequently asked question by the inventors community. And so today I am going to answer this question, that what exactly is the step-by-step process followed to patent an invention. My name is Dr. Prachi Chopra, founder and director, Intellect Bastion. And I'll try my best to answer this question, but if still you are having any kind of doubts and maybe something is not answered by me, which may be in your mind, you can always write it in the comment box and I'll try to answer it in a timely manner. Plus, if you are an inventor and you are likely to have such kind of questions in future as well, since I am going to answer these questions in future in my future videos as well, so you can always subscribe to my channel so that you get to know about more of such videos in the future as well. So let's get started. What exactly is the process followed to patent an invention? Starting with the first step, which is patent searching. What exactly is patent searching? In patent searching, we try to find out, maybe if you have an invention, as an inventor, you always think like my invention is novel, no one has done such kind of work. But it's not always such a case. And as an inventor, we are emotionally attached to our invention. And so we don't think very skeptically, logically, and we don't try to find out prior arts. But it is our responsibility as an attorney that we need to be very skeptical before advocating your application. So what we try to find out prior arts which may be same, similar, or kind of equivalent to your invention. Why this is important is, it is important for two main purposes. Number one, if it's like some part of your invention, no invention is completely novel. There are some improvements that an inventor do to whatever is available as a prior art. So there are some improvements over whatever has been already done. So globally, this search is done globally, and if in case that it's like some of the part we find it's always it's already available in the prior art, then we try to find out, focus exactly on which areas where the inventive step lies, where exactly is the realm of invention, where exactly is the focus of the invention, your inventive step which you have done, which can be further emphasized in the draft when we file the patent application. So we try to find out the exact part of your novelty and then emphasize it and make it more prominent while drafting, so that the examiner has a quick look over the what exactly is the inventive part. Nextly, it may be such a case that more of it is in the prior art and we don't feel like going for filing. We may think of like there may be some kind of modifications which are required. So which inventor is not able to find out. So it's better to navigate, it's better to guide you through those parts of your invention where you can focus more and hence enhance your invention more on those parts and come out with a better invention which can be further filed, and the chances of grant are more in that. So this is the very reason that why patent searching is important, and we reasonably predict those prior arts. After doing patent searching, the next stage is to do patent drafting. In patent drafting, looking through whatever are the conclusionary remarks of the patent searching, we try to draft your patent application. The patent application is drafted as a document, techno-legal document of almost 20 to 30 or more sheets, trying to interpret your invention in the best possible way, so that an average person, a person having average skill in your art, is able to do that invention, is able to engineer that invention on his or her own by looking through that whole techno-legal draft. It should have the abstract, the description, claims, most important part, claims, that is the boundary of your inventive protection, where you ask for the patent protection, the whole boundaries of those patent protection, and summary and figures, professional figure drawings, and field of invention. These are the different kinds of sub points on which the patent draft includes in a very detailed manner. What we have to think, what should be our mindset while writing the patent draft is the audience in mind. We have to keep our audience in mind, because otherwise there may be cases of indefiniteness and lack of proper description in the draft. These may be raised out by the examiner that you have not properly written everything in your patent draft, and there should be more of the claim diversity. Claim are the actual boundary of your patent protection, which should be very detailed, written in a techno-legal way, in functional, structural form, picture claims, narrow, broad, and medium broadness claims. So it should be written in a very diversified way, so that any chances of future infringements are avoided, future cases are avoided, and we are able to provide the best possible protection to our inventors. The next stage which is followed after patent drafting is form preparation and filing. In form preparation, numerous forms are prepared, like form number 1, 2, 3, 5, 9, form number 26, 28, depending on the type of entity, depending on the type of requirement, depending on the various other requirements. Like form number 26 is for power of attorney, that you are authorizing us to file the patent on your behalf. It's an affidavit form. So form number 1, 2, and form number 28. So these are the different forms which are prepared, signed, and then filed along with the specification, which is the patent draft, plus a file of professional drawings which are relevant to your draft, describing your draft in the best possible way. This is the process of patent filing, which is covered in a span of almost 15 to 30 days, depending on the complexity of your invention. This completes over a span of maximum, depends on the complexity of your invention, but usually between 15 to 30 or maybe 45 days, depending on the complexity of your invention. Further on, in India, if I talk specifically about India, the patent examination process is not automatic. There is a need to file patent examination request. Like in USA, it is automatic. It's like an examination request is filed in an automatic manner while filing the application, which is always like the examination will be done. But in India, you have to file a special request with a prescribed fee to the government on Indian Patent Office website, that you request to file a patent examination request, and that should be done within 4 years of your filing date, within the 4 years of the date on which you have filed your patent application. It should be first filing stage. If there are further more subsequent applications filed in different other countries, there are two types of examination requests. One is normal examination request and another one is expedited examination request. In case of normal examination request, the government responds back to you with objections towards the novelty, non-obviousness, and industrial applicability of your invention in a span of almost 2 to 3 years. But in case of expedited examination request, which actually depends on certain terms and conditions, if you fulfill those conditions, you can always apply for expedited examination request with a prescribed fees, and government responds back to you in almost 3 to 4 months, and with all the objections related to your invention. Once that examination report is received, which is first examination report, the next step is to respond back to the Indian Patent Office with relevant responses, with proper evidences, related to whatever objections the government has raised, Indian Patent Office has raised, within a span of 6 months. It's a deadline that you have to respond back to with proper response within 6 months from the date of receiving the examination report. So and that's a comprehensive report, and for each and every objection which is being raised by the Indian Patent Office, which is pointed out by the Indian Patent Office, with proper relevant proofs and evidences, you have to respond back in a form of report that how your invention is novel and why should it be granted, where does the novelty lie with respect to whatever objections the Indian Patent Office has raised. You have to either amend, there is a need to either amend or argue or cancel in favor of whatever is the cited art. So there are the 3 options which are always available with you. If you think that your position, your evidences with respect to whatever is the objection is well found, they are well found, and you find yourself on the stronger part, it's always good to argue. But if you find that the other party is somewhat stronger in whatever objection they are raising, it's always better to amend. So it depends, and always depends on the experience of your attorney as well, and your intuition as well, what you think. So it's always, what we always try is, we try to interact with our inventor to discuss with him or her that what you exactly think, where is the stronger part at the part of the inventor, on your part or on the examiner's side, and we actually write down the report depending on that. So this is how we prepare the examination response to the first examination report. And then after filing the first examination report, which is to be filed within a span of 6 months from the filing date, the next stage is hearing, which depends on case to case. Actually, the government may ask for it, government may not ask for it. They can simply grant it or not grant it. If they are not convinced, they can ask for a hearing part, which is a face-to-face session with you or your attorney if he is doing the procedures on your behalf, and it's maybe virtually or maybe in office, in the patent office. So depends on the situations at that point of time. Like in COVID times, the hearing part was conducted virtually most often. So after hearing, the patent office then decides that your patent will be granted or not granted. It's completely up to the discretion of the examiner, up to the discretion of the controller, that your patent will be granted, your invention will be granted or not. If it is granted, you get a certificate of grant, and if it's not granted, then it's the other way out. But that's why I say it's best to do patent searching before before leaping into the patenting process, so that you make your part much more stronger. During the prosecution stage, you are having stronger evidences of proving out your novel part, and the chances of grant are enhanced this way. That's why patent searching is the most crucial part out of all these stages, and it's the first part which is to be followed before diving into the patenting process. If you still have any kind of questions, you can always write in the comment box. I'll try to answer in the most timely and the best possible way. I may direct message you for the same as well. And please subscribe to my channel if you're an inventor. If you are an inventor and it's like your mind always tries to find out such kind of answers, IP related questions, you can always subscribe to my channel. Thank you so much.